Hi everyone, this is Pennsylvania attorney Evan Gutman presenting video number 19 of my video legal education series, which is based upon my book, State Bar Admissions and the Bootlegger's Son. The book is available on both of my websites, one of which is titled heavensadmissions.com and the other is titled gutmanvaluations.com. The websites also have a supplement that I wrote to the book a few years later, as well as a fictional novel, which is titled Heaven's Admissions Process, which is kind of a fun, humorous novel that compares the criteria for being admitted into heaven with the criteria for obtaining a law license on earth as regards the good moral character requirement is concerned. You should find, if you're looking at this on Facebook, links also to a PDF for this specific video. The video is also available on my YouTube channel, which contains links to my website. In addition, I have two Facebook pages. One is my personal page. The other is titled Judicial Constructive Criticism Network, which is also the title of the YouTube page. So today's topic, the topic for this video is, can the judiciary withstand scrutiny under its own state bar admissions standards? In other words, what they try to have the applicants do they do it themselves, or are they hypocritical? And my position is they're quite hypocritical. The criteria for obtaining a law license with respect to good moral character encompasses positive character traits of truthfulness, candor, honesty, and complete disclosure. In addition, it encompasses negative character traits of non-disclosure, false disclosure, misleading disclosure, and evasiveness. So in chapter 19 of my book, I address a number of aspects of the judiciary branch of government to demonstrate that they really don't meet the standard. And I'm going to go over some of them today, and then I'm going to go over more of them actually in the next video, which will be video 20. So video 19 is actually comprised of two parts. This is part one. So the first thing I'm going to address is where the judiciary does not meet its own standard is unauthorized practice of law prohibitions. The concept of the unauthorized practice of law is that you have to have a law license to be able to practice. If you don't have a law license, it's the unauthorized practice of law. So you're not supposed to do it. And the state bar's justification, purported justification, I should say, for the UPL prohibitions, unauthorized practice of law, referred to as UPL, is that by having UPL prohibitions and requiring people to obtain legal advice from an attorney, people receive more competent legal services than if they would otherwise receive such from someone who's not licensed. Now, often that's true. They do basically, because a lawyer presumably should have some knowledge of the law, and if a person has no knowledge of the law, they're not going to be particularly helpful. But there are a lot of people who have extensive knowledge of the law, who are not allowed to provide that knowledge to others who need it for free, and they could do a better job than attorneys, particularly if they're licensed in one state and not licensed in the state they're living. If they practice, it's considered the unauthorized practice of law. The UPL argument, in my view, is under the competency argument. The competency argument is severely undercut by the fact that within a litigation, every single contested motion, even if both parties are represented by an attorney, one attorney's right and one attorney is wrong. So that means basically that as far as competency goes, as a matter of logistics, with respect to every contested motion, 50% of the attorneys are wrong as a matter of law. So that's the first item, UPL prohibitions. The next one I want to cover is Miranda rights and their importance with respect to our legal system. Everybody's watched a TV show where someone has read what's known as their Miranda rights, which actually comes from the case of Arizona versus Miranda, or excuse me, Miranda versus Arizona, which is a 1966 case. And basically, if you're arrested, the police officer will say, you have the right to remain silent, you have the right to an attorney, if you choose to give up that right, you waive the right to remain silent, and anything you say can and will be used against you. I have no problem with that holding. But here's the issue. If it's so important with respect to police officers to inform citizens of their Miranda right to remain silent, then why don't judges inform litigants in a case that you have a right to request disqualification of the judge if you believe the judge is biased against you? Because ultimately the police officer is in a situation where they have to respond quickly. I would be more inclined to give the police officer leeway and less inclined to give the judge leeway. The judge is basically in a generally safe courtroom protected by officers and has the time for reflection with respect to any decision, and it's critical to the litigation that the judge be fair and impartial. So my position is that in the same manner police officers are required to advise arrestees of their Miranda rights, I believe that judges have an equal duty to inform litigants of their right to move for judicial disqualification if they genuinely believe and have grounds to assert that the judge is biased against them. That's the second thing. The third thing is judicial elections. For those states that have judicial elections, some states don't even have a judicial election. The judges are appointed by the governor. In other states, basically, there are elections for trial court judges, but not appellate judges. In some states, trial court judges as well as appellate judges are elected. For those states that have judicial elections, my position is that they also cannot withstand scrutiny under state bar admission standards for the following reason. What very often happens, is a judge's term will expire in a certain year. And what they do, it's like an unwritten understanding between judges, is that rather than wait the term out so that their seat comes up for election, instead what they do is they announce their retirement about 5 or 6 months prior to their term ending. And when they do that, at least to fill the last 5 months of their term, the governor then does have to appoint someone to fill the seat, at least temporarily, until the election. And what that does is that allows the governor's appointee to become the incumbent judge when election time comes. And it's well known that incumbent judges typically win over new people running for election, so they have a huge advantage in the election process if they've been appointed 4, 5, 6 months prior to the expiration of the term and the judicial election that would then ensue. By doing that, the judges are really engaging in an act of deception to evade and circumvent the electoral process. So judicial elections, when they occur, to the extent that judges retire 4, 5, 6 months prior to expiration of their term, do not meet scrutiny under state bar admission standards of fairness. The next item that I'm going to address is what's known as AWOPs, A-W-O-P. AWOP stands for Affirmed Without Opinion. And in Chapter 19, I basically have a title with respect to this section, which states AWOPs equal judge slop and cannot withstand scrutiny. AWOPs equal judge slop. Because the concept is that if you have important issues, there should at least be an opinion written to resolve those issues, instead of simply having an appellate court say, we affirm and we don't issue any opinion whatsoever. When they do that, quite often they are dodging an important issue because they know if they would write an opinion, they can't justify affirming the lower court or reversing the lower court if it's summary in nature. But typically it's affirmed. It's called AWOP equal judge stop, affirmed without opinion. By issuing these AWOPs, the appellate courts are being evasive and, in all fairness, quite chicken. They're being cowards because they don't have the courage to address important issues of society. It's well known that the U.S. Supreme Court consistently dodges many, many issues. The next item I'm going to address here is what's known as the Star Chamber. Now, the Star Chamber, in many respects, has its roots from English jurisprudence. And what basically happened within the Star Chamber is that the courts would not simply require litigants to have an attorney, but then they would basically have that attorney be in a position where anything they file has to have the approval of the court. So the concept being the litigant really doesn't get to defend himself or herself in the manner that they believe is best for their defense. Instead, they're subjected to an attorney who is doing what's known typically as selling them out. And it occurs quite often in the United States. Here are some interesting quotes from U.S. Supreme Court cases about the Star Chamber. Probably the most significant one is in the 1975 case of Ferretta versus California. That's Ferretta versus California, 1975. And the court wrote as follows, which describes the Star Chamber pretty well. In the long history of British criminal jurisprudence, there was only one tribunal that ever adopted a practice of forcing counsel upon an unwilling defendant in a criminal proceeding. The tribunal was the Star Chamber. That curious institution, which flourished in the late 16th and early 17th centuries, was of mixed executive and judicial character and characteristically departed from common law traditions. For those reasons, and because it specialized in trying political offenses, the Star Chamber has for centuries symbolized disregard of basic human rights. The Star Chamber not merely allowed, but required defendants to have counsel. The defendant's answer to an indictment was not accepted unless it was signed by counsel. When counsel refused to sign the answer for whatever reason, the defendant was considered to have confessed. The Star Chamber was swept away in 1641 by the revolutionary fervor of the Long Parliament. The notion of obligatory counsel disappeared with it. Counsel had to be cautious that any pleadings they signed would not unduly offend the crown. Another good quote about the Star Chamber is in the 1967 case of In Re Gall. The U.S. Supreme Court wrote as follows: "We are warned that the system must not degenerate into a Star Chamber proceeding with the judge imposing his own particular brand of culture and morals on indigent people." In the case of Pearson v. Ray, 1967, U.S. Supreme Court wrote as follows: "Historically, judicial immunity was a corollary to that theory. Since the king could do no wrong, the judges, his delegates for dispensing justice, ought not to be drawn into question for any supposed corruption." The importance of public proceedings, having matters that occur in court not be secret and should be disclosed to the public, was best summarized in the U.S. Supreme Court case of In Re Oliver, a 1948 case. This is to basically avoid a Star Chamber type of environment. And the court wrote as follows: "Suppose the proceedings to be completely secret, and the court on the occasion to consist of no more than a single judge. That judge will be at once indolent and arbitrary. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. And I'm going to address one other item here today, where basically where the judiciary does not withstand scrutiny under the state bar admissions character standards of truthfulness, full disclosure, not being evasive, not being secretive, in fact, just overall not being fair. And that is basically the judiciary consistently talks about the importance of it being a separate and independent branch of government. But the bottom line is that when it comes right down to it, the judiciary has no problem whatsoever with our state legislatures and our Congress being infiltrated by massive numbers of lawyers who are elected to office. And once the judiciary controls the licensing of the attorneys, and those same attorneys get into office by ballot elections in state governments and the U.S. Congress, then effectively the judiciary, to a large extent, is controlling not only the judiciary, but also the legislative branch of government. So I'll continue with more items on this tomorrow, or maybe not tomorrow, within the next day, 2, 3, 4. I never know when I'm going to release my next video, but they're generally just a few days. I hope you enjoyed today, and we'll see you in the next video, or you'll see me in the next video anyway. And remember, love right, don't fight. Bye, everybody.